the Asian Australian Lawyers Association for the opportunity to open Climate Conscious Lawyering, Fighting for Environmental Justice in the Asia Pacific panel. I'm Justice Nicola from the Land and Environment Court of New South Wales. I'd like to begin by acknowledging the traditional owners of the land on which I am recording today, the Gadigal people of the Eora Nation, and I pay my respects to elders past and present. I would also like to honour the at least 60,000 years in which Aboriginal and Torres Strait Islanders have cared for country, from which stewardship we can learn much. I'm hopefully going to be setting the scene for today's panel. The Asia Pacific region includes, as you all know, a great variety of nations with diverse cultures, religions, economies, histories, and of course, legal systems. Many of these countries are part of the Global South and face substantial equitable development challenges. There is also no doubt that countries in the Global South are bearing and will continue to bear the substantial adverse impacts of climate change. The impacts of climate change are unfortunately well understood in nations in the Pacific Oceans, with many small island Pacific nations acutely aware of the existential crisis they face due to sea level rise. The Alliance of Small Island States, AOSIS, Group of Nations, has long been a negotiating bloc in international climate change treaty negotiations, commencing with the United Nations Framework Convention on Climate Change agreed in 1992 and many subsequent agreements. The Pacific Forum is a regional organisation facilitating dialogue between its 18 member countries, and it recently released its 51st Leaders Communique, which reaffirmed the urgency of action on climate action to limit global warming to 1.5 degrees Celsius. The Asian Development Bank is an organisation with 68 government members established in 1966. And it has funded substantial work investigating the science and regulation of climate change in the Asia Pacific. In December 2020, it released a series of 4 reports entitled Climate Change, Coming Soon to a Court Near You. The first of those reports deals with climate science, the second, climate litigation in the Asia Pacific and beyond. The third looks at national climate change legal frameworks in the Asia Pacific, and fourth, the International Climate Change Legal Framework. And these are invaluable resources for those interested in legal responses to climate change in the Asia Pacific region. The United Nations Environment Programme has also been instrumental in promoting the environmental rule of law, including by providing materials for judicial education. For example, it has published in a series of 3 to date the Judicial Handbook on Environmental Law, and has undertaken a number of global surveys of climate change litigation in 2017 and 2020. As no doubt many of you know, the rise of climate change litigation is well documented in the Sabin Centre for Climate Change Law database based at Columbia University, and also the Climate Change Laws of the World database maintained by the Grantham Research Institute on Climate Change and the Environment at the London School of Economics. A database of climate change jurisprudence in ASEAN jurisdictions was launched online in 2021 by Litigation. When these databases were recently interrogated in relation to the Asia Pacific region, the countries which the Sabin Centre database identified as having climate change cases were Australia, Chile, India, Indonesia, Japan, Nepal, New Zealand, Papua New Guinea, Pakistan, Philippines, South Korea and Taiwan. Litigation's database relating to ASEAN countries also identified a number of countries, including Thailand, Malaysia, Vietnam and Cambodia, as jurisdictions with climate cases. Several countries in South Asia in particular have a strong tradition of public interest environmental litigation based on their democratic and fundamental rights-based constitutional schemes. I'm here referring to Pakistan, Nepal and Bangladesh and India, and in the southeast of Asia, the Philippines. I'd like to refer briefly to a couple of innovative cases in some of these countries' domestic courts. It is of course not possible in the short time I have to undertake a comprehensive analysis of this case law, and I will focus on a few key cases. Brief mention of Australia will also be made by way of contrast at the end. I note interestingly that there has been no rights-based climate litigation in the Pacific Islands, and the cases I focus on will draw from Asia. The cases I think show the importance of, firstly, the role of superior and apex courts making substantive decisions in this area. Secondly, the absence of procedural impediments such as limiting standing to sue and encouraging access to justice by courts. The innovative reasoning applied by judges in considering a number of issues such as multiple sources being called on to derive environmental law principles. And finally, but not least, a willingness on the part of these courts to craft extensive remedies. Turning first to India. The Supreme Court of India is recognised for its innovation in public interest litigation over many decades in terms of reducing procedural impediments, engaging jurisdiction under the Indian Constitution in human rights matters, and imposing innovative remedies. Its many judgments in cases commenced by the public interest lawyer MC Mehta over decades are well known, and I refer to here examples such as the Taj Mahal case. The cases are frankly far too numerous to summarise. The Indian Supreme Court appears to be the first in South Asia to have extended the constitutional right to life to include a right to a clean environment. I'd like to mention the National Green Tribunal, which was established in 2010 and has also taken innovative action in the climate change context, including on its own motion. In the case of INRI Court on its own motion in Himachal Pradesh, the National Green Tribunal initiated its own case against the state of Himachal Pradesh. It found that 40% of glacial retreat in the Rotung Pass could be attributed to emissions of black carbon. It relied on the state's constitutional mandate to protect and improve the environment under articles in the Constitution and the obligations of citizens to protect and improve the natural environment under another article of the Constitution of India. It also noted the right to life under Article 21 includes the right to a clean and decent environment, as had been found in many earlier cases by the Supreme Court. The tribunal undertook a detailed analysis of environmental jurisprudence and analysed the environmental threats to the Rotung Pass, including from climate change. Pardon me. The tribunal found that the provincial government had not formulated enough specific guidelines on the prevention and control of environmental degradation in relation to the glacier of the Rotung Pass, and it issued extensive directions to seek to remedy that. So it found there was a cause of action, it applied innovative reasoning, and it did apply innovative remedies. These included creating a monitoring committee to tour the area and engage with the court to ensure these directions had been complied with. So a very unusual, by Australian perspectives, approach to the situation. In Pakistan superior courts have shown great willingness to address environmental degradation in public interest litigation, and they rely a lot on the Constitution of Pakistan. That does not contain an explicit right to a healthy environment, but the right to life and dignity of man articles in 9 and 14 have been applied to show a right to a healthy environment exists in Pakistani law, and this has been applied to impose positive obligations on the state. The rules of standing have been relaxed in public interest litigation. One well-known case of Sheila Zia and Wakta is a key authority in which the Supreme Court of Pakistan established that the right to life includes the right to a healthy environment. In one case decided in 2018, which many of you may well be familiar with, the Agrarian Federation of Pakistan, the focus was climate change policy or lack of in Pakistan. The petitioner filed a complaint in the High Court of Lahore alleging that the national government of Pakistan had failed to implement the National Climate Change Policy of 2012 and a framework required under it. The petition argued that the climate change is a serious threat to water, food and energy security in Pakistan, and that offended the fundamental right to life under Article 9 of the Constitution, and the right to human dignity under Article 14, and these gave rise to a right to a healthy and clean environment, and Sheila Zia reasoning was applied. The court treated the petition as a public interest petition akin to a continuing mandamus or writ of Kalikasan, which was a procedure adopted from the Philippine Supreme Court. It applied innovative reasoning, holding that existing environmental jurisprudence must be fashioned to meet the needs of addressing climate change. It adopted a lens of climate justice rather than environmental justice, considering the latter term of environmental justice was too localised. The importance of climate adaptation in Pakistan was emphasised. The principle of water justice as a sub-principle of climate justice was also said to be arise and was protected by Articles 9 and 14 of the Pakistani Constitution. The court held that the length and delay on the part of the state in implementing the framework for climate change policy offended the fundamental rights of citizens and conceived of innovative remedies. During proceedings which commenced in 2015, the court constituted a climate change commission consisting of environmental experts, federal and provincial government representatives, interest groups and the Petitioners' Council. That body was dissolved in the final judgment in 2018, and at that point a standing committee on climate change was enabled to act as a link between the court and the executive and to render assistance to the federal government to ensure the policy and framework were implemented. I'd like now to turn to Nepal, which shares with Pakistan and India a common law legal system with extensive constitutional human rights protection. And it has also proved fertile ground for constitutional human rights-based climate litigation. In Shrestha, an officer of the Prime Minister, the petitioner filed suit in the Supreme Court of Nepal seeking mandamus or another appropriate order to protect the interest of all biodiversity in Nepal, alleging violations of Article 16, which is a right to live with dignity, and other rights concerning right to a clean environment, right to healthcare and right to food under the Constitution of Nepal. Provisions of the Environmental Protection Act of 1997 were also considered. The court found that standing was satisfied in holding that climate change directly affected the well-being of citizens who were guaranteed a constitutional right to a clean environment, and found there was a meaningful relationship between the issues and the petitioner. The court applied innovative reasoning. It recognised the devastating consequences of climate change for Nepal and found the national government had failed to take any effective action to address those impacts. It found that a comprehensive law addressing climate change had not been passed, and the Environment Protection Act of 1997 was not focused on climate change, and there was essentially a gap in the law. He endorsed the principle of climate justice, referred to sustainable development as including and intergenerational equity, and found that climate change was further held to implicate the rights to life and to have nutritious food, those being rights under the Constitution. It also formulated some interesting remedies. It provided for a new consolidated climate change law, which it considered was necessary. It issued orders requiring the government to introduce such laws in a separate consolidated law addressing climate mitigation and adaptation as soon as possible. And indeed, that has come to pass in the sense that those laws have been passed since that case in 2019. I thought I'd just briefly mention for interest a couple of interesting cases from South Korea. The first of these is Do Hun Kim and South Korea, which has been underway since 2020, so it's still not concluded. The plaintiffs are youth climate activists, and they're asserting in the Constitutional Court of South Korea that the climate change law of South Korea violates their constitutional rights, including the right to life, the right to a clean and healthy environment, the obligation to prevent natural disasters and protect safety, and the obligation to protect health and safety. They argue that the target of 24% cut in emissions from 2017 by 2030 is too weak to keep warming to under 2 degrees Celsius. A further novel case in South Korea, which has been concluded, was held in the District Court of Seoul. In March 22, a Korean national and 3 Tiwi Islanders filed suit seeking an injunction against the Korea Trade Insurance Corporation and the Korea Export-Import Bank. Those two organisations are planning to provide credit for a Santos development seeking to exploit the Barossa gas reserve near the Tiwi Islands off the coast of the Northern Territory. The plaintiffs, who include traditional owners of the Tiwi Islands, allege that this project will cause environmental harm, including through the emission of carbon dioxide, that the development is therefore incompatible with the Paris Agreement, and they relied on articles in the Constitution of South Korea, which does expressly provide for a right to a healthy and pleasant environment. The District Court did dismiss that case in May 2022, and an appeal is being considered. I'll just briefly comment on Australian climate litigation by way of contrast essentially to the cases above. As you would be aware, Australia's 1901 Constitution lacks human rights provisions which have been the basis for many of the cases outlined already. Climate litigation in Australia is reasonably large in volume, and it is identified as second by a substantial margin to the volume of litigation in the United States of America in the Sabin Centre database. Because of constitutional arrangements in Australia, litigation is occurring in not only state courts but the federal court, with varied types of cases reflecting the different jurisdictions being exercised. Until relatively recently, cases were often judicial review or merits appeals of administrative, environmental and planning decisions about single projects, generally large generators directly or indirectly of greenhouse gas emissions in state courts, this often involving coal mines. This type of litigation, which is ongoing, dates back to the early 1990s with Greenpeace Australia Limited and Redbank Power Company Proprietary Limited and Singleton Council, decided in the Land and Environment Court. Such an approach has achieved some notable successes, but also some salient failures. An interesting recent case is the application of orthodox principles and existing laws to new subject matter, in which the applicants were successful, being Bushfire Survivors for Climate Action Incorporated and Environment Protection Authority, which was decided in 2021 by the Chief Judge of the Land and Environment Court. In judicial review proceedings, the applicant sought an order in the nature of mandamus to compel the New South Wales Environment Protection Authority to perform a statutory duty under a particular section of the Protection of the Environment Administration Act. It was argued this required the development of instruments to protect the environment of New South Wales from climate change. Section 9, which is the section in question, does impose a duty to develop environmental quality objectives, guidelines and policies to ensure environment protection. The court considered the evidence and found the threat of climate change is of sufficient magnitude and impact to be one against which the duty should be protected. That there should be formulation and application of the duty to climate change. And the court found that duty remained unperformed, having considered the existing instruments prepared by the EPA. The court issued mandamus to compel the EPA to develop environmental quality objectives, guidelines and policies. And the EPA at this stage is yet to announce a policy in response to the court's judgment. In conclusion, climate change litigation in the Asian region is resulting in some novel cases, and many of these are focusing on constitutional rights in the examples above. Procedural impediments have been few and wide-ranging remedies imposed in several cases. Such cases are only possible because of climate-conscious lawyering, as courts generally hear matters brought before them by parties who present evidence and make submissions which identifies to the court the issues to be determined, with the National Green Tribunal case that I referred to being something of an exception, where the tribunal acted on its own motion. I trust the rest of the panel discussion further enlightens this very important topic for the Asia Pacific region. Thank you.